this is an effort to basically rig the results before that midterm election. And this Supreme Court is complicit in trying to stop fair representation in Congress and asserts this is an effort to basically rig the results before that midterm election. And this Supreme Court is complicit in trying to stop fair representation in Congress and assert some sort of colorblind America that does not exist in reality and certainly does not exist in the way that these white legislatures have been acting in targeting Black voters.
And to resist any temptation for them to divide us. We're in this together. The rule of law is on our side. We will not give in, not give up. We will not capitulate. We will not bow. We will not bend. We will survive.
You know, I've heard a lot of people talk about what's legal and what's not legal. That's not legal what they're doing. Well, slavery was legal at one point, and it looks like the Supreme Court can pretty much make a decision that your right to vote can be not something that you'll have moving forward for the near foreseeable future, as well as whether or not the National Guard can come into your neighborhood and do whatever they want without any check, because the Supreme Court is a co-equal branch of government, and they right now are, I believe, compromised, but I don't know if my guest believes that as well. She just wrote a book called Without Precedent: How Chief Justice Roberts and His Accomplices Rewrote the Constitution and Dismantled Our Rights. Let me welcome the one and only Lisa Graves, former Deputy Assistant Attorney General in the Office of Legal Policy at the Department of Justice. Welcome, Professor.
Thank you. Thank you so much, Karen. I love that applause that you play for guests. Thank you very much. That's awfully kind of you. And it's an honor to be on your show and have the chance to speak to your listeners.
Listen, this is important. I don't spend a lot of time talking about this because I feel like it's a fait accompli. So I want to lean into what we can do, because the Supreme Court is 6-3 on any given day. Maybe Amy Coney Barrett will have a conscious awakening, and sometimes John Roberts seems like he's having, a crisis within himself. But this is what they wanted to happen. So walk us through how. And who are the accomplices of Chief Justice Roberts?
Well, so I wrote this book because I think most people don't really know who John Roberts is, and what you don't know about John Roberts could hurt you. In fact, John Roberts has spent, from the beginning of his career until now, he began his career assailing the Voting Rights Act. He basically got his first real job at the Justice Department because he was clerking for the justice who was most hostile to the Voting Rights Act. That was Bill Rehnquist at the time. And he was put in charge of trying to block a congressional effort to overturn a Supreme Court decision that really harmed Section 2 of the Voting Rights Act. And we can talk a bit more about that provision and the Voting Rights Act in general. But he got that job because the guy who had spent his time, Bill Rehnquist, had spent his time in Phoenix targeting Black voters in the neighborhood of Bethune to intimidate them from voting. The guy who actually urged his justice, the justice he clerked for, Robert Jackson, to dissent from the decision in Brown versus Board of Education, that's who was the mentor. That's who John Roberts stodged for, that guy. And that guy called someone who later became more famous, Ken Starr, and asked Ken Starr to hire John Roberts as a special advisor at the top of the Justice Department to aid the Attorney General in this effort, basically that the Department of Justice undertook to block Congress from reversing a decision that hurt the Voting Rights Act just 15 years into its action. And so now here we are in 2025 with John Roberts at the helm of the court and with these other accomplices, the other Republican appointees to the court who were chosen not because they were believed to be fair, but because they were believed to be ringers, that they would be sure votes to advance this regressive agenda. Now this court is considering decimating this, the last real portion standing of the Voting Rights Act protections, and doing so at a time when Donald Trump is trying to rig the midterms in advance by changing the maps in order to secure illegitimate Republican majority in Congress.
Because he knows if Congress flips, his time is up. Possibly, but who knows? Lisa Graves, so walk us through what is the Voting Rights Act and why was it such an important decision?
Well, after the Civil War, there was an effort by Congress to protect voting rights, to address the terrible harms that have been occurring for centuries in America through the enslavement of people, and they passed statutes saying that, of course, people who are free have a right to vote. They have the right to equal protection of the law. But at that time, the U.S. Supreme Court was blocking those statutes. So it required an actual amendment to our Constitution in the 14th Amendment to specify that Black citizens, Black men at the time, have a right to vote. And then the 15th Amendment to say clearly, unequivocally, that Black men have a right to vote in America. And then ultimately, decades later, that all women have a right to vote in America. And even though that was the command of the Constitution as of the late 1860s, shortly thereafter, there was a real betrayal of that effort to advance equality in America, equal protection of the laws, equal citizenship, equal rights for housing and commerce and voting. There was a betrayal, and that betrayal took the form, as you know, of the Jim Crow laws, the racial apartheid in America that the U.S. Supreme Court then approved of and blessed. And so for the 100 years between the end of the Civil War until 1865, that right to vote was assailed in countless ways in jurisdictions across the country, not just in the South, but certainly in the former Confederacy, but also in the North, in terms of making it harder for African Americans to vote. There were poll taxes, there were literacy tests that only applied to some. There were so-called grandfather clauses where people didn't have to take the test if their grandfather had voted before the Civil War. And so this reaction to the immediate aftermath of the Civil War, where for the first time in American history, Blacks were elected to Congress, to state houses, that was untenable to this racist authoritarian component of American society, and the Supreme Court allowed that. So in oh yes,
can we pause? Yeah, because
yeah,
I think it's important for people to really understand. 1,500 Black men were elected in every facet, and we're talking about the Hiram Revels and the Robert
yeah,
Smalls, and these very erudite, beautiful Blanche Bruces, and
yeah,
beautiful men. And then shortly thereafter, we have Birth of a Nation.
yes,
Right. So not only poll taxes and the literacy tests and all of this, which 4 million Africans were not allowed to read during enslavement. So literary tests it's
yeah,
all right there. But then you put out this propaganda piece showing them in Congress with their shoes off, eating fried chicken and watermelon,
yeah,
throwing the chicken bones in Congress and stuff, which is antithetical to the way they were showing up, the most dignified,
absolutely,
right?
absolutely.
But that was impactful for people who wanted to deny people the right to be humans. That was
That's
impactful.
That's right. And that movie was shown at the White House under President Wilson. It was embraced, the Ku Klux Klan, the white supremacy, the vigilante violence, the lynchings, the destruction of Black bodies and Black rights was the dominant norm in American society. And after World War II, there was an alliance for a period between Harry Truman, President Truman, and the NAACP to ensure that our armed forces were integrated. And Truman spoke as someone, he said, as a Missourian who came from this white supremacist state in this white supremacist regime, that he was sickened to hear that Black soldiers coming home from fighting in Europe, fighting against Nazis in Europe, fighting to defend freedom in Europe, would be mistreated back here in America. And so he was determined to integrate the armed services, and ordered that to be so. And then a few years later, in the Brown versus Board of Education decision in 1954, the Supreme Court finally ruled that the 14th Amendment that guarantees equal protection of the law meant what it said, and that you could not racially segregate school children. You could not create separate white and Black schools, or white and Black water fountains, or white and Black entrances, but it was focused on schools. But that notion that separate is inherently unequal was core to that ruling. That's the ruling that Bill Rehnquist tried to get the justice he worked for to dissent from. So that 1954 decision by the Supreme Court, which was profound, of course, was assailed by regressive white supremacist forces in America, and was assailed by the John Birch Society that was born shortly thereafter, was assailed by other parts of this right-wing so-called movement. And in the midst of this, from the 30s, 40s, 50s, 60s, as you know, and your listeners know, there was a tremendous, vibrant civil rights movement. People lost their lives, children lost their lives. It was the Civil Rights Act of 1964, the Voting Rights Act of 1965. They were purchased with the blood, sweat, and tears of African Americans and the descendants of people who had been captured and enslaved, and others who allied and stood by their side to protect these rights. It was profound. And it was, signed into law by a man who had considered himself a racist, LBJ. But he also, ultimately ended up supporting that Voting Rights Act because of the tremendous, public demand for fairness in America.
Can we pause there again?
Yeah.
LBJ was a racist. Lincoln was a racist before he met Frederick Douglass, and I don't know if he died, enlightened, much enlightened. He didn't free people. He didn't sign the Emancipation Proclamation because he loved black people. It was a strategy, right?
He didn't sign it until 1863. Yeah, yeah.
And I'm from Jersey, so I know Jersey was like, we still own people while we're in this war because we're in the Union. I want to just say, politicians aren't our friends. They don't have to be good people. They are servants, and they can be forced to do things when we show up.
Yeah.
And LBJ knew without black people, you're not winning anything.
Yeah.
And so it wasn't because he loved black people. Adam Clayton Powell was there poking. And then we were there with all of the apparati. I don't know if that's Latin, but all of the organizations pressing him into service. So I just want to underscore that because I think even today we miss that point that this is not a purity test. This is about rights and resources. So let's vote accordingly.
That's right. And LBJ, in signing that into law, when he was basically finally forced and Congress overwhelmingly supported the Voting Rights Act, when he signed into law, he then fully embraced it. And he said that the right to vote is the most powerful tool that a person can have to use to advance their interests, to use to fight injustice. And so I suppose we shouldn't be surprised that there now has been a multi-decade effort to erode that gain, to fight that gain. But here we are at a zenith now in this most recent decade, since John Roberts issued the ruling in Shelby County back in 2013, which took out the key pre-clearance provisions that were in the Voting Rights Act that required for jurisdictions that had a history of racial discrimination, they couldn't change a polling place without getting approval because of course they would misuse those powers. Of course they would use those powers to make it harder for blacks to secure representation. And now this court is hearing a case coming out of Louisiana, which has more than 1/3 of the population in Alabama are Black Americans, and that white legislature drew maps that had 5 white majority districts and 1 Black majority district, and that's an anathema in essence to this continued or this resurgence of this effort to have white racial domination, to bleach out our legislatures, just like they did in the aftermath of that tremendous success following the Civil War of having such beautiful, vibrant diversity, such powerful voices and voices of dignity in the legislature. This is another effort to go back in time to that white supremacist era to bleach out our legislatures. That's what's at stake. And as you point out, and you point out a number of times, Karen, but in many ways, in many settings, an election isn't a Valentine. This is not your partner. This is not your spouse. This is not the person you're going to date. This is the person who you are electing like a chess move in order to protect your rights, advance your interests, protect your family, help make sure that things aren't rigged against you, whether it's through on the issues of rights or the economy and more. And so this effort that's underway right now to basically stop the American people from reacting to these policies that are harming them from, coming through this administration, these extreme policies to blunt the popular will in reaction to the cutting of aid programs and so much more. This is an effort to basically rig the results before that midterm election. And this Supreme Court is complicit in trying to stop fair representation in Congress and assert some sort of colorblind America that does not exist in reality and certainly does not exist in the way that these white legislatures have been acting in targeting Black voters. And that election in South Carolina in 2024, where the lower courts found that that white legislature in South Carolina had sought to suppress black voting, moved over 20,000 members of the Gullah community, 20,000 black
Gullah,
Americans.
Gullah.
Gullah, sorry,
Geechee
Gullah.
Gullah. Yep, that's all right.
Sorry. I'm a northerner. Sorry about that. Gullah community. 20,000 black voters, bleached 20,000 black voters out of the district that they and their ancestors had voted in order to secure Nancy Mace's first district seat in South Carolina. The lower court said, looked at all the findings, all the claims, found that that was a racial gerrymander. But this court, the Roberts Court, said that that was just a partisan gerrymander and that was okay, which is what opened the door for Texas to say that it could try to rip away black representation in Texas and just say it's not racist, it's partisan. And so this court has been at the center of destroying some of the most fundamental rights, including not just of the Gullah community on the shore of South Carolina, but now in state after state.
We're ready. We're prepared. Do not give in to fear. We are fearless. This is not the time to be afraid. This is a time to stand up and fight back and to resist any temptation for them to divide us. We're in this together. The rule of law is on our side. We will not give in, not give up. We will not capitulate. We will not bow. We will not bend.